Hey, what's going on, everybody? Welcome back to Alphonso Speaks and more of the Darrell Brooks trial. Before we get started today, make sure you like the video, share the video if you like it, and subscribe to the channel for more great content. If you haven't done so already, check out the Independent Voter Reacts, where we're following election 2024, and things are getting interesting in the comment section. My God. But we've got videos coming out very frequently for that. So what I'd like to check out today is some more of Darrell Brooks's lowlights. This is where he gets upset and he's like, the judge is pulling fast maneuvers. Let's just take a look at it. It's about 20 minutes long. It's from one of the, I think this is the first day of his defense, actually. So let's check it out.
Put in place yesterday.
I want to state for the record that I intend to appeal that judicial decision made about the motion to dismiss.
Noted for the record. All right, let's bring the jury out then.
Actually, we didn't address subject matter jurisdiction. It still has yet to be proven for the record. And I wanted to address the fact that with this, is it Kohler? Is that how you pronounce the name? Kohler?
We're going to continue with the witnesses. I've addressed subject matter jurisdiction repeatedly. There's a written decision. I stand behind it. You have 3 witnesses that you subpoenaed. The state made arrangements for them to be here. Whatever order you want to call them in this morning is fine, but those 3 are here.
That's what I was trying to address right now. I was asking about
go ahead.
the name.
What do you want to address?
The Kohler, how do you pronounce the name? Kohler? I'm still
I don't know.
having
You'll have to ask the witness.
I'm still having trouble finding the file for that particular witness.
So the classic Darrell Brooks, I'm not prepared, so it's everybody else's fault. We need to adjourn this this day of trial. We need to push it back. We need to give me more time because I can't find my files.
Yeah, call the jury in.
So I don't know how I'm supposed to.
Mr. Brooks, you were well advised. These are your witnesses that the state made arrangements. You knew who was going to be called. I put that on the record yesterday. So of those 3, whatever order you want, but I'm not moving past those 3 to jump to others.
I didn't say anything about moving past the 3.
I know that. I'm just setting the tone for today that we're going to keep moving.
Okay, I simply stated I'm not ready to ask that witness questions if I can't even find the
I understand,
paperwork.
but that's you not having your paperwork's on you, not anybody else.
So what am I supposed to ask him?
I can't answer that, sir. You know that.
That's a rush to judgment. You can't rush me to judgment.
This is the most ridiculous argument. The most ridiculous argument he could have possibly made in this situation. Like, how are you with a straight face on saying that somebody's rushing to judgment because you're not organized and you can't find your paperwork? When she just made it very clear. She put it on the record. The day before this, she made it well known. Sir, you will be calling these 3 witnesses today. Tomorrow, rather. Like, these are your 3 witnesses. So it's not like she came up with a brand new list of witnesses the morning of. Like, you knew this headed into that day of trial, and you still didn't make sure that you were prepared. That's not on anybody else but you. That's painfully obvious to any of us watching. Like, I shouldn't even have to explain that, but since Darrell doesn't seem to get it, I guess I'll provide that commentary.
I mean, when I'm notifying the court that I cannot find the record.
Well, you did very well yesterday without your file, so
I'm saying that particular witness.
She just made another point. Like, the day before that, you probably weren't even using your files. So, like, what are we talking about here? You were just questioning witnesses without really tapping into the files too much. So it shouldn't be an issue today.
I'll make a record. Yesterday you asked a question, hold on a second. Can you have them step back out? Just they can. Yesterday, you said you did not have a file for one of the witnesses, and you did a fine job from my perspective. So
I did what?
You did a fine job. I just want to say my assessment.
They also
you did
provided
a good
me
job.
with 1 sheet for that particular witness at that time.
Okay.
So I just went off of that 3 paragraphs.
How you're prepared or not is solely on you, sir. You've had all of this information. Now we're at the end of the 3rd week of trial. These are your witnesses. I presume that you are prepared in whatever way that is.
How can I be prepared for? I'm not. So the witness is just supposed to get up there and I'm not
going to have this commentary, okay? I'm done. The jury's coming out. Be prepared to call
So
one of the
that's a
three.
rush to judgment.
That is not a rush to judgment.
It is a rush
Again,
to
I'm done.
judgment.
The jury's
It's clearly
coming
a
in.
rush to judgment if I'm telling you that I don't have the
No,
file.
in
How
my
am I
opinion,
supposed?
you're attempting to delay. So
No,
let's
I'm not.
keep
I'm not
going.
attempting to delay nothing. You want to come check the boxes yourself? You always trying to pull some fast maneuvers.
Mr. Brooks,
And Miss Judge, Your Honor.
Mr. Brooks, the jury's coming in.
Yeah,
Show
and
respect
they
to
they
the
deserve
jury.
to know this too. It's still issues that need to get addressed. We didn't even address everything.
Mr. Brooks, I addressed all of the issues.
No, I
You
still
know
had another one that didn't have nothing to do with nothing we just talked about.
All
There
right.
was a whole nother issue that needed to be addressed that I needed to
And we'll
bring on
address
the
it
record to
later.
your attention.
We'll address it later.
It needs to get addressed now before we go any further because it's an important matter. Just like the subject matter jurisdiction is important. That hasn't been proven on the record.
Ladies and gentlemen of the jury,
Just
this
like
is
the
not
rush to
the
judgment.
time for evidence to be presented or arguments to be made by the
I
parties.
can't
The
even
jury
present
will
any evidence. You won't let me even put
disregard.
any evidence in the record.
So he thinks that this is helping him because of so many of you have said in the comment section, and I didn't really realize, but he really thought, and I didn't know this either. I didn't know that there were actual courts because I've never been a convicted criminal, so I wouldn't know. There's courts in America where the jury decides if you're guilty and they decide your sentence. I think he thought that that's what was going to happen here. So every time the jury comes in, he's putting on a show for the jury. He's disrespecting the judge because he doesn't think the judge really has any standing in what ends up ultimately happening to him. Like, he didn't realize until it was too late that the judge is going to be the one sentencing you. The jury's just going to find you innocent or guilty. But even still, he thought that these antics would help him. He thought that they would help him convince this jury full of Waukesha County citizens that he was innocent of this vile crime that they're accusing him of doing because he was angry in the first place. And so you're displaying that anger. You're putting that on full display. That is the best piece of evidence, along with the videos and pictures and everything like that and the first-hand accounts. That's the best piece of evidence that they had right in front of them in the courtroom. Your personality right there, your traits, the things that make you Darrell Brooks, they got to see them firsthand. You laid it all out there for them. So good job. You convicted yourself.
All of these statements
is a
made
rush
by
judgment.
Mr. Brooks
That's
at this
unfair.
time. All right.
That's unfair what
The
you're
court
doing.
will address legal matters outside the
Then we
presence.
need to
Everyone
address
can
the
be
legal
seated.
matter that I was trying to get to before
And
you
you
rush
may call your
everything
next
out.
witness, sir.
I'm not calling any witness until I get an answer, Your Honor. You're a public servant.
Mr.
You're
Brooks,
supposed to be able to answer simple questions.
Mr. Brooks.
If I'm saying I have to bring
call
it to
your
your
next
attention,
witness, please. That's the stage that
I have
we
to
are
bring
at.
it to your attention, Your Honor.
Mr. Brooks,
I'm merely seeking
please
to bring
stop.
an issue to your attention.
I'm telling you to please, I'm asking you to please
And
stop.
I'm asking you,
because
can we
we have the
address-
jury present.
I'm asking
and
you-
we need to continue with the evidentiary phase of this trial. Call your next
I'm
witness.
asking you to address a legal matter, as you said, that those have to be taken up outside of the jury.
I will
There
do
was
that
a
at the
legal
next
matter-
break.
There was a legal matter that needed to be addressed beforehand,
I
so
will
we
do
don't
it.
have to take up time,
I will do
valuable
it at the
time
next break.
afterwards to address something that needs to be addressed now. That way,
Mr.
the
Brooks,
court and you
for the
yourself are
third
on
time,
notice.
I will address it at the next break.
These are the tactics that worked on his mother his whole life. Just so you guys know, that's why he keeps doing this. That's why he keeps trying it, because this worked on Don his entire life. This is the first time really he's getting significant pushback on this kind of behavior. Because usually it works. Usually it's not a big problem, but now it is.
Break. Call your next witness, please.
Are you asking me?
I'm directing you to call your next witness.
Your Honor, we're not going to move past this, seeing as how you took an oath to protect the Constitution. I have your oath. I have a copy of your oath.
To protect the Constitution, the same one that you don't consider a governing document over yourself because you're a sovereign citizen. So you guys remember this. He argues his constitutional rights, but also argues the fact that he's not under the jurisdiction of the Constitution. You can't make it up.
Oath, right here. The oath that you took, Your Honor.
Mr. Brooks, I'd like to continue with testimony.
Sir.
We have witnesses waiting for you. Please call your next witness.
The oath that you swore to protect the Constitution, which you are now not doing.
Mr. Brooks,
So you're going
call your
against
next
your
witness,
sworn
please.
oath. You're going against your sworn oath.
Mr. Brooks, call your next witness.
As you notify the jury every time when there's legal matters, we take them outside of their presence.
And we're going to take testimony right now. Call your next
I
witness.
merely seek to put you on notice on the record for something that needs to be brought to your attention and to the court's attention.
And I will address it at the
That's
next
what I'm
break.
merely seeking to do. It's something that shouldn't have to wait because it'll take a valuable time later. At least if I notify you right from the onset, you'll already know what we're looking at, and we can nip it in the bud before everything starts to roll. And
Mr.
then
Brooks,
it gets over.
Like you can just see, man, this stuff. This is what he used to do every single day. This would literally get him out of trouble with his mom all the time, and he thinks it's just gonna work on any woman in his life. But you're dealing with professionals now, man. Like you can't possibly think that this is your best bet. I mean, again, I've said this before too. I'm like, I can't really blame him for thinking like this is my best shot because all the evidence was stacked against him. The only thing he could do is try to get a reaction out of the lawyers or the judge or somebody in the audience in order to get the case thrown out, in order to get an appeal. That's what he was trying to do, but everybody played their role so well. Even the families of the victims really played their role really well. They sat there and they allowed themselves to be subjected to this because they knew what the ultimate goal was, and that was to put this guy behind bars. And they knew if they interfered in any way, it could threaten that possibility. So everybody did their thing. He swore up and down during the trial, "Oh, y'all don't know who y'all messing with. I'm far from an idiot." Well, everybody in there is far from idiots too. And if you're far from an idiot, they're super geniuses. They're rocket scientists.
I will address it at the next break. If you want to write something down, that's fine, and give it to my clerk. I have nothing in writing. I know there's witnesses available and ready to go. Call your next witness.
Your Honor, Your Honor, you have to answer this question. You're
Mr.
making a
Brooks,
judicial determination.
Call
to
your
rush
next
me to
witness,
judgment.
please.
You're rushing me to judgment, Your Honor.
There's no rush to judgment.
There is
here,
a rush
sir.
to judgment. If you won't address a legal issue that I informed you that I had some legal issues that needed to be addressed before you just run right past that, Your Honor. You're a public
Mr.
servant.
Brooks,
Are you not a
it is
public servant?
9:37. Call
It is
your...
8:37.
Sorry, 8:37. You're right. Call your next witness.
Your Honor, you're rushing me to judgment.
There's no rush to judgment. Call your next witness,
We had
please.
a legal matter that needed to be addressed, and I'm merely trying to
And I'm
notify the court.
Telling you
at
I'm
the
denying the
onset.
request to address it at this moment. Call your next witness.
You said what?
I'm denying your request to address it at this moment. Please
How
call.
how can you deny
please
something that we're supposed to do before
Mr.
the jury
Brooks.
even comes out?
call your witness.
I'm not seeking to be disruptive. I'm just seeking to understand why we do this
Everyone
every day.
is in the courtroom waiting for you. Please call your
Your
next
Honor,
witness.
we do this every single day. We've done it every single day. So I'm simply trying to make sure that the court is notified of
Put it
things
in
that need to
writing,
be
hand it to the
discussed.
bailiff, and if I deem it important enough to interrupt the witness, I will, but call your next witness.
How can I call a witness and write something down and do
You
the
can
vote?
take a minute
This
to
is the
write down what it is.
This
I'm not
the
asking
reason
you
why
to...
it needed to be addressed beforehand.
Mr. Brooks,
That way
the
it
jury
doesn't
is
become an
remaining in
issue.
this courtroom. Call your next witness, please.
Your Honor, you're rushing me to judgment.
There's no rush to judgment, sir.
Are you not a public servant, Your Honor?
Mr. Brooks,
Do I not have your oath of office?
under 90611, this court has the authority, as you know.
Do I not have,
Call.
is this not a copy, or I asked for certified copies that you said on record that you would not provide for no good reason, that these are three of your
you are
oaths
doing this,
right
and I've
here.
repeatedly told you, you can see the jury's here.
You're
You're doing this.
Listen,
we
Your
need to go
I'm
forward.
I'm not attempting to delay the proceedings. I'm not attempting to be disruptive. I'm merely trying to notify Your Honor in the court for the record beforehand. That way, everyone's at least on notice of the issues that need to be taken up, instead of waiting until a break or a lunch and things of that nature, which kills
In my
valuable
discretion,
time.
it's my authority, it's the courtroom that I'm
Your Honor.
presiding over. I'm not going to address
Is
that
this-
at this moment.
is this not your
And
oath?
I'm not going to answer
Did you not
questions.
swear as a public servant that you would protect the
Mr.
United
Brooks,
States Constitution?
call
Did you not do
your
that?
witness.
3 times. I have all of them here. Your oath, Your Honor, as a public servant. And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed
Mr. Brooks,
beforehand.
we are
I wonder why he took the mask off here. Like, he looks so stupid holding these papers, but I wonder why. I wonder why he took the mask off at this particular moment. Like, what was that all about? Like, obviously it's theatrics, but like, what specific theatrics was he trying to pull right here? Like, what was the difference between the mask being off now and like a few minutes earlier, the mask being on and him like making the same arguments? Like, what is the difference?
Mr.
Now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed.
Mr.
I think the funniest part about Darrell, like physically, is that like his head legit looks like it belongs on a bigger body. Like, you look at his head, he looks like a grown man from like the neck up, right? Like, he's got a full connecting beard. It's a little bit patchy, but it's full, it's connecting. His hairline's starting to recede, so you know he has like some age on him. Like, the neck down, it's like it just never grew. Like, he never grew into his head. Like, if you see pictures of him when he was younger, like with his family and stuff, like, he has a huge head. But, you know, he's a kid. You're thinking like he's gonna grow into this. Like, I'm sure you guys have seen kids with like huge heads before. And you're like, oh my goodness, their neck is struggling, but they'll grow into it. They will grow into that head of theirs, and they ultimately end up growing into their head. Darrell looks like he never grew into his head. Like, his head just remained too big for his body the entire time. It's wow.
Brooks,
Beforehand.
we are in
These
the
were issues-
evidentiary phase of this trial.
Your Honor, you're
Call
rushing
your
me to
next
judgment.
witness.
You're rushing me to judgment, Your Honor. And I object
I'm
to
aware
that.
of 3 witnesses
I
who are
object-
here.
I object
Call
to
one
that.
of them, please.
Your Honor, I object to that.
Your objection's noted.
And
for the
I
record.
want a legal reconsideration of your ruling. If not, I reject that ruling and take exception to that ruling.
I understand.
I request a legal or a factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling. And if not that, an interlocutory, declaratory appeal for this matter. And if not, these need to be stayed until this matter is before a adjudicated court of competent jurisdiction.
He has no idea what any of that means. That's the funny part. He doesn't know what any of that means. He's reading off of his sovereign citizen script, and he's just saying words. Some of them he's not really sure if he's pronouncing them correctly, but he's giving it his best shot. Maybe it has the phonetic spelling on it. I don't know. But, I mean, look at his face right now. That is the face of somebody who just spent a lot of energy trying to get those words out. He's exhausted. Or in his words, I'm tired, Your Honor. I'm tired. I'm tired. I don't want to do this with the, I don't want to live with this pain anymore.
Because we have not proven jurisdiction in this court as of yet. Subject matter jurisdiction has not even been proven on the record, Your Honor. I don't even know the true nature and cause of
Mr.
the
Brooks,
charges against me. I don't even understand that part
I
of it.
understand
I haven't
your
been
request.
provided a complaint. I haven't. Your Honor, there's so many issues.
Mr.
and
Brooks,
I'm not
we will
attempting,
take-
I'm not attempting to,
Mr.
to
Brooks,
be disrespectful in any way.
We
I'm
need
not
to
attempting
continue.
to delay the proceedings
Your
in any
requests
way.
are denied.
Your Honor, I
And I'm going to
respectfully
instruct the
object
jury
that.
at this point to
I
disregard
respectfully
and not
object to
consider
that, Your
any
Honor.
of what has just happened since you walked in. It should not be held against Mr. Brooks in any way. These are legal issues that this court may or may not need to address, but they do not bear in any way on ultimately the issues that you as jurors will have to decide. And I'm instructing you to disregard what you have just heard and seen.
Your Honor, with everything that I just said, be made part of the record.
It's on the record. I'm telling the jury that it shouldn't affect anything that they're doing in any way.
Your Honor, it's a
With
rush
that-
it's a rush to judgment
Mr. Brooks,
because, Your Honor, I just showed your oath that you swore to took. You swore you
Mr.
did
Brooks,
this, Your Honor.
please call your next witness.
You took these oath of offices. You did, Your Honor. 3.
These oath of offices. It's oaths of office. There's one office, multiple oaths. Oaths of office, not oath of offices.
Of them.
I understand my oath,
Which is
sir,
very,
very
very
well.
commendable that, you know, that you decided to be a public servant in these type of matters, Your Honor. I respect it to the fullest, but also you have to uphold these oaths that
All right,
you
I'm going to have
took,
to
Your Honor.
excuse the jury since Mr. Brooks is
have
not
to-
calling his witness. We'll
have to-
hopefully
you have
bring
to-
you back out shortly.
You have to
All right.
honor these oath of offices. You have to, as a public servant, Your Honor. I respect you being a public servant. And this is not to take a shot at you in any way.
Bro, if I was Judge Darrell, I strongly would have considered, like, if you don't call your witness, you're just going to forfeit your right to call any further witnesses and put on any type of defense. Like, that's what's going to happen. But, again, she was being super duper careful, trying to make sure she didn't, like, mess this case up.
But these
Mr.
issues
Brooks,
that I have,
stop. Please
they
stop.
need to be addressed. They need
I'm
to be.
excusing the jury. Can you please stop?
Your Honor, this is a rush to judgment. This is a clear bias.
Mr. Brooks, you are to stop talking.
Are you asking me?
I'm advising you, or you will forfeit your right to be present in this
So you're holding
courtroom
me
for
in
the
contempt?
questioning of your first witness.
Because you're holding me in contempt.
I'm not holding you in contempt.
Then how can you remove me from the courtroom when I haven't given consent?
Mr. Brooks, I'm
can you do
advising
that?
you at this moment to call your next witness, or you will forfeit the right to call these witnesses.
You can't take my
Under
Sixth Amendment
906.11,
right.
you are
cannot-
refusing to
you
call
cannot-
a witness.
I didn't refuse anything, Your Honor, and you can't deny me my Sixth Amendment right.
But you're a sovereign citizen. You don't go by the rules of the Constitution. What do you mean your Sixth Amendment right?
Which is
Mr.
to
Brooks,
call
do you want to
witnesses,
be present in
which
this
is to subpoena
courtroom
witnesses.
while you question your first witness? Because it is now 8:44, and you've consistently talked in front of the jury who's no longer in this courtroom on issues that you have been advised and are fully aware are not relevant to their determination, despite what you
This-
believe the law
this didn't have anything
is.
to do with the jury,
Subject
Your Honor.
matter that is what you referenced in front of the jury, and then you
that
referenced
after I
my
had raised
oath.
the issues that I was
Subject
trying to
matter
raise.
jurisdiction, as you know, is not
As I
something
don't know.
the state has to be, the
It
state
has
must
to be
prove.
proven. It has to be. And
You are
if it doesn't,
frankly
show me lawful
confusing
law.
civil
Show me lawful
jurisdiction
law,
in
Your Honor.
federal cases with criminal court jurisdiction in the state of
You
Wisconsin.
don't have criminal.
That
you
has
don't
been
even
made
have,
abundantly
You don't
clear.
have subject matter jurisdiction or personal jurisdiction.
Mr. Brooks.
Or personnel jurisdiction. You don't. You haven't proven.
You have not,
You
I
haven't proven
excuse
for
the
record.
jury. I'll give you the opportunity to raise whatever issue it was, but you need to do it now or we're moving forward.
That's what I want to do. That's what I
So-
was attempting to do.
And if you interrupt me one more time, you're gonna go do it from the other courtroom.
And
Because
so
you're
you're holding
being,
me in contempt?
all right. He can go to the other courtroom and we will address these issues because
holding
you
me in
are
contempt?
not being respectful, you are disruptive, you are interrupting. I will give you one more opportunity. Don't interrupt me again. Don't roll your eyes at me. Don't sigh at me. You have delayed these proceedings.
He's like, this face right here specifically is the face that he should see every day when he wonders why he's getting assaulted in prison, why he's getting jumped, his ribs broken, why no guards are taking him seriously, none of them are taking him to the infirmary. This face right here, this attitude right here, you have this attitude somehow. You're acting like this when you're on trial for murdering 6 people. I just can't understand it. I can't fathom how somebody turns out like this. I just don't understand.
Now by 15 minutes because of your nonstop commentary. I'm going to sit down and I'm going to listen to you. What issue do you want to raise, sir?
So are you letting me make an offer of proof for my appeal?
No, because that's not what's relevant at this time, sir. If you don't need to make an offer of proof. Tell me what the issue is. You said
Okay.
you have a legal issue you want to raise before we get going. What is that?
This is the best part where we find out there was no legal issue at all. It was exactly what we thought it was, him stalling.
That issue?
Okay. The legal issue is this. Detective Casey yesterday testified for the second time under oath in reference to exhibits 13 and 14 that show the backyard of my mother's home, which he stated that he had been to the home, had seen the backyard, all this stuff, when he did not, in fact, even speak with my mother. It was brought to my attention that my mother, in fact, never spoke to any law enforcement from Waukesha.
Would you like to add her to your witness list to call her?
Yes, I would.
All right, that's
because
fine.
She's
That's
willing,
how we'll
she's
address
willing
that.
to come.
But that's not something we needed to address this
It needs
right
to
away,
be addressed
sir.
because of the issue of the subpoena. That's the reason why it needed to be addressed. That's the reason why I was trying to attempt to
It
bring
could
it
have
to
been
your
done on a
attention.
break. All right, so
Will I be?
you're
because I
putting, you're asking me to add Don Woods to the witness list for you.
Yes, but I also have a question about the subpoena
The subpoena for whom?
for my mother. But I would also like to subpoena the phone records so it can be made part of the record of the conversation, since the prosecution listens to all the phone calls. They should be able to have heard that phone call as well. So they should be on notice of what was said.
I don't know what phone call you're referring to. If
I'm
you're referring to a jail phone call,
I'm referring to
then
a jail phone call that was made last night, October 20th, between 7:54 p.m. and 8:10 p.m., which I'm sure the prosecution has heard by now. And that also brings up the issue of perjury testimony.
sir, the way that you will address the issues that you're talking about are to call witnesses to challenge that or to present the evidence in support of your position. If you're telling me you need to add Dawn Woods to the witness list, I approve of that. You can fill out a subpoena and I'll direct the state to serve that upon her, and at the appropriate time we'll have her brought. We'll indicate when in the order of folks she can be brought in. So I'll grant that request.
Will I be
In
able
terms
to,
of the jail records, you'll have to subpoena the appropriate custodian or a witness who can testify to that.
that's what I was trying to gain knowledge of, because
Well, I can't give you advice on that,
I'm
sir.
not trying to ask for advice. I was, is that
That's
legal for
asking
me to
me
subpoena?
for, I can't direct how you do that. I can't tell you how to do that. You are acting as your own attorney and you will need to figure that out. So you have the subpoena forms. You can research the issues. You have access to legal research materials and other things. And that's how you'll have to address
I accept
that.
for value in return for value this document.
Was that a subpoena form? It is. Thank you. Is there any other witnesses you're asking to add to your, and you can also call Detective Casey if you want, just so you know.
So that make 3 times he's able to testify?
If you believe he has information that he hasn't testified to, I will give you permission to call him as well.
No, I don't think it'd be necessary. He know what he did.
Well, in any event,
He know what he didn't do.
we're gonna bring the jury back out, and then I expect you to call a witness.
And just so I'm clear, because I was trying to get to that issue, what witnesses are here? Because I don't have any paperwork for Kohler. I don't know. how to
Douglas
pronounce
Kohler,
it.
Stephen Guth, and Erica Patterson. Of those 3, I expect you to call one of those witnesses.
I accept for value in return for value this document.
For the record, Judge, Attorney Witchow just handed to the defendant for his benefit the police report as it relates to the statement of Douglas Kohler, since he's claiming he does not have it.
Since I know that I don't have it. So let's make that record correct.
You don't have it with you in the courtroom is what you're saying.
I can't find it anywhere.
You've had it previously.
Yes, I had it at one point.
All right.
Yeah, this dude's just. I think what gets me about Darrell is like the faces that he makes. Again, a lot of you have alluded to it. He thinks he's smarter than everybody else. Thinks he has a leg up. And like Attorney Suaper said in the sentencing statements, He sits there thinking he's in control of everything when in reality he's in control of nothing. He's in custody, in control of absolutely nothing. And all he can do is sit there. All he can do is sit there. Yeah, it's I don't get it, guys. We're just gonna keep watching the trial because I don't understand. I really don't get this dude, man. We need a psychologist up in here to explain this man, because this is crazy. I've done my best to explain why I feel like he acts the way it does. I know it has a lot to do with how he was raised with no accountability, but it's got to be something else there. It's got to be something like screw loose or something in there. It's got to be. But that'll be it for now. Like the video, share the video, subscribe to the channel for more great content. And again, don't forget to check out Independent Voter Reacts, brand new series where we're following the election 2024 and hopefully beyond that as well. Until then, stay safe, stay blessed, and I'll see you guys in the next video. Peace.